Page 81, Chapter 7, Findings and Recommendations. As a supplement to the corresponding section in the 2018 NCD report, below are additional findings and federal-level recommendations designed to improve the experience of people with IDDD in systems of guardianship and in the implementation of less restrictive alternatives. Key findings and recommendations. Finding 1. The lack of data on existing guardianships and newly filed guardianship includes information on the specific nature of the person's disability, thus making it difficult to have reliable state and national information on how guardianship systems impact people with IDDD and whether that population is likely to be in limited or full guardianship than people with other disabilities. Recommendations. The Social Security Administration has data based on disability-related eligibility listings. Therefore, it should not only conduct data on whether individuals it serves are subject to guardianship, but trend it against the type of disability. Offer states incentives and technical assistance with developing electronic filing and reporting systems that collect basic information about guardianships, including the alleged disability of the person served, as well as their age, among the other information recommended in the 2018 NCD report. The National Core Indicators (NCI) website should also specify on a state-by-state basis precisely to what population of people with IDDD the state is administering its survey, so that one can assess whether the data collected is truly representative of the full population of people with IDDD in that state. Finding 2. People with IDDD currently are at higher risk for guardianship because of the school-to-guardianship pipeline. Recommendations. The U.S. Department of Education, OSERS, renewed its previously archived 2017 Transition Guide to Post-Secondary Education and Employment for Students and Youth with Disabilities, which recognized the serious implication of guardianship and encouraged schools to recognize SDM and other less restrictive decision-making support for adults in special education. Page 82. Key findings and recommendations continued. OSERS should do more to promote implementation of this guide at the state and local level, including requiring state educational agencies to ensure robust and repeated trainings of educational professionals at the agency and school level on options for supporting the decision-making of adult students with disabilities, including people with IDDD that are less restrictive than guardianship. Create a modified FERPA form for the transition process that documents SDM arrangements that ensure parents and caregivers can support transition-age youth in making educational decisions after rights transfer to them. Ensure local school systems do not unlawfully discriminate against adult students with disabilities who wish to exercise their civil right to execute a power of attorney or under state law. Develop tracking mechanisms to determine how decision-making rights are exercised by and/or for adult students in special education to assess and monitor the use of guardianship and alternatives by transition-age youth. OSIP should instruct its parent training and information centers to prioritize and provide meaningful training on school-to-adult transition and alternatives to guardianship. The Department of Education should issue a Dear Colleague letter to all teacher education programs and vocational rehabilitation agencies, urging them to cover the full range of decision-making options in their transition programming and instruction of accommodations for people with IDDD. The Department of Education should issue regulations and/or guidance clarifying the requirements for states that The Department of Education should issue regulations and/or guidance clarifying the requirements for states that, pursuant to their own state law, create an educational representative appointment option for adult students who cannot provide informed consent for their special education services, pursuant to IDEA, Law Number 30 U.S.C. 1415M2, and its regulations 34 CFR 300.520b. When such appointment is triggered by a parent's request or an alleged certification of incapacity, States must require that 1. Less restrictive options such as educational powers of attorney or other voluntary delegation by the student are exhausted first, and B. Such appointments are easily challengeable by the students involved through, for example, a mere objection rather than by a due process hearing before an administrative law judge. Page 83. Key findings and recommendations continued. Finding 3. A minority of states have guardianship provisions that are applicable solely to people with IDDD as opposed to other alleged disabilities. While some of these statutes incorporate additional procedure safeguards, there is not demonstrable proof that they are advancing the due process and substantive rights of people with IDDD in practice and in treating people with IDDD uniquely, may be promoting unfavorable stereotypes about the inherent capacity or incapacity of this population. In addition, these statutes could represent an ADA violation for discriminating against people with different disabilities. Recommendations. The U.S. Department of Justice should take the position that the degree of due process in a guardianship matter under state law or practice should not be different for people with IDDD simply because of their diagnosis, and states that have such statutes or practices are engaging in discrimination under the ADA. The State Adult Guardianship Court Improvement Program that NCD recommends be created and funded in the 2018 NCD report should require that guardianship be used as a matter of last resort and that the person's functional abilities be assessed on an individualized basis rather than on the basis of the person having an IDDD, consistent with the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. Finding 4. While more states should advance alternatives to guardianship in their state laws, regulations, and policies, more is required to ensure that these changes are fully implemented on the ground, creating a cultural shift at the judicial, governmental agency, and business levels that significantly recognizes and advances the decision-making rights of people with IDDD. Recommendations. DOJ should issue guidance to states on their legal obligations pursuant to the ADA in the context of ensuring that guardianship should be a last resort that is imposed only after less restrictive alternatives have been determined to be inappropriate or ineffective. This guidance should include requirements that states consider including benchmarks related to SDM in their Olmstead plans. The State Adult Guardianship Court Improvement Program referenced above should require states to not fund probate court resource centers that only provide pro se assistance to people seeking guardianship. Those resource centers should also provide people with information about less restrictive alternatives under state law, such as SDM, powers of attorney, representative payees, and substitute or surrogate healthcare decision makers. Page 84. Key findings and recommendations continued. Ensure that there is an unconditional right to counsel for people in initial and post-appointment guardianship proceedings, and that counsel is expressly required to zealously advocate for their clients' expressed wishes. Provide judicial and attorney trainings on the availability of less restrictive options for decision-making support under state law. The DOJ should issue guidance to states on how to minimize the risk of overuse or misuse of involuntary non-judicial alternatives to guardianship, such as those in educational or health matters, which raise due process concerns. States should legally require ruling out voluntary options, such as SDM and powers of attorney, before such involuntary options can be used. Those involuntary options should also be easily challenged by the person. The U.S. Department of Health and Human Services should explore ways to facilitate decision-making support for people with IDDD, particularly for those who may not have a large network of trusted family members and friends. This should include providing funding to support community service such as health advocate programs in which a supporter attends medical appointments, assists the supported person with understanding and making major medical decisions, and acts as a facilitator between the supported person and his or her doctor. Financial case management services, including regular meetings with supported individuals to discuss budgeting, establishing direct debit and deposits, and assisting in the management and recertification of public benefits. Educational advocate services to help adult students with IDDD understand and make educational decisions. Examples of this type of support could include attending IEP meetings. Educational advocate services to help adult students with IDDD understand and make educational decisions. Examples of this type of support could include attending IEP meetings, assisting with transition planning, and facilitating communication between the supported person and education officials. Finding number 5. Despite the existence of restoration of rights procedures in many state laws, many people with IDDD and their families are unaware of those options, let alone the broad array of less restrictive options. People with IDDD may therefore remain in guardianships that are overbroad or undue for most of their lives. Page 85. Key findings and recommendations continued. Recommendations. The State Adult Guardianship Court Improvement Program referenced above should require states to regularly notify people in guardianships, their guardians, and other interested parties in their life that guardianship need not be permanent and that there are concrete ways to pursue restoration of rights. Periodically review guardianships to determine whether they remain the least restrictive option or should be modified or terminated. Train family and professional guardians on using SDM within a court-appointed guardianship to increase self-determination and the potential for restoration of rights. Train people in guardianship on ways in which they can complain about their guardian and initiate restoration of rights proceedings. Finding 6. There is a dearth of reliable data on the number of adult abuse, neglect, and exploitation cases in which the perpetrator is the court-appointed guardian or other substitute decision maker of the victim. According to the National Adult Maltreatment Reporting System, NAMRS, 18 states do not collect any perpetrator information. Of the states that do track general perpetrator information, the vast majority do not collect specific information regarding a perpetrator's role as the court-appointed guardian or other substitute decision maker. Although the NAMRS requests data from states about the perpetrator's role as the victim's court-appointed guardian or other substitute decision maker, in 2017 only 4 states submitted data for the start of the investigation. No state has ever submitted data to NAMRS for the end of the investigation. Recommendations. States should continue to be encouraged through the NAMRS and other mechanisms to collect, track, and report the number of cases in which perpetrators are the victim's court-appointed guardian or other substitute decision maker. The State Adult Guardianship Court Improvement Program referenced above should require that state courts review the annual reports of guardians for signs of unusual or deficient accounting and signs of abuse and neglect. Page 86 is blank.